Yes, it's very
good. Lords, before inviting your lordships to continue your journey, and in the case of my Lord, Lord Reed, relive your journey through the earlier hearing in this court, you may find it helpful if I give you some roadmap of where I would like to go with my submissions, a bit like a sat-nav, judicial obstructions permitting. The way I would like to present my case is this. After dealing with what's happened in this court, I would go on to look at the way in which the DMG decision endorsing the Kleinwort-Benson decision has underpinned the development of both statute law and case law. Then to indicate how all the problems which have emerged and been alighted on by my learned friend could and should have been avoided many years ago. Then to show that equating mistakes of fact and mistakes of law in the context of limitation is entirely principled. And then to come to the nub of the problem that your lordships have been noting, to look at the context of section 32(1)(c), to look at the concept of the context of the various provisions in the Limitation Act, to deal with the AB case, the AB and Ministry of Defence case, in the context of personal injuries, latent defects, etc. And then, as I say, specifically to look at the context of section 32, which deals with fraud, concealment, and mistake, and to show you that by focusing on the context and look at the case law that has developed in relation to those contexts, there is a principled and entirely practical solution to the issue that you have to deal with. When I say principled and practical solution, there is a sensible time limit that can be applied to section 32(1)(c) in cases of mistake both of law and of fact. I'll come to that when I've been through the rest. But we're not going to be left with some indeterminate period going into the time when man lands on Mars before there needs to be a claim made. There is a sensible end point to limitation which emerges from the cases in section 32. Finally, I've come to the actual legal issue which your lordships have to determine, and that is whether to depart from the decision of the House of Lords in Kleinwort-Benson and DMG. And I hope by that time I would demonstrate not merely would it be wrong in terms of the practice statement to depart, it would just be wrong to depart. Let me just make one other comment by way of preface. It's been criticism of Lord Gough's way of dealing with the extended time period under 32(1)(c). He was dealing with one payment that was out of time. It wasn't a major issue. There wasn't major debate. Focus increased in the DMG case and increased in this case before this court in 2012. It's quite wrong to criticise Lord Gough for not going into more detail. He uses expressions like indeterminate, etc. He didn't need to go into more detail. he did not have the benefit of very extensive discussion about what is the right test, etc., in the context of Section 32. Your Lordships will have the benefit, if that's not too arrogant an expression, will have the benefit of that focus here. So, having said that, can I ask you please to go back to what was said in this court at the earlier hearing, in the same volume, core volume 2, at tab 14, manuscript page 4495, we come to the end of Lord Walker's judgment and to Lord Brown. And if we turn to the manuscript page 4517, at paragraph 121, it says, I've had the great advantage of reading in draft the judgments of Lord Walker and Lord Sumption, and am in full agreement with both of them on the several issues upon which they each agree. Well, we've seen what Lord Walker says, and you'll see that Lord Sumption agrees with Lord Walker on that issue. Lord Clark at page 4518 says at paragraph 126, in para 9 above, Lord Hope has conveniently identified 4 issues for determination in this appeal. Issues 3 and 4, which raise a question of construction of section 32(1)(c) of the Limitation Act 1980 and the ingredients of the common law Woolwich claim respectively. Now, I emphasise respectively because he's making the point that issues 3 and 4 raise a question of construction of 32(1)(c). That was the issue 3. And the ingredients of the common law Woolwich claim respectively raise no issue of EC law. I agree with the other members of the court that for the reasons they give, the decisions of the Court of Appeal on both questions should be upheld and that both questions should be answered no. At the end of the argument, I was inclined to the view that section 32(1)(c) should be given the wider meaning contended for by the test claimants. That's it should extend to the Woolwich claim where mistake wasn't an essential ingredient. But I've been persuaded by the reasoning of Lord Walker and Lord Sumption that it should not. And then Lord Dyson at page 4522. I too agree at paragraph 140. I too agree with the judgments of Lord Walker and Lord Sumption on all the issues on which they agree. Like Lord Hope and Lord Reid, I agree with Lord Walker on the DMG section 320 issue. Then Lord Sumption, he begins at page 4522, but if one turns to 4543, above paragraph 177, it's the heading, the section 32(1)(c) point. He sets out section 32(1). And then if one goes to over the page at 4544 to 179, section 32(1) of the Limitation Act 1980 substantially reenacts section 26 of the Limitation Act 1939 with one minor change to paragraph B from concealment by fraud to deliberate concealment. The Act of 1939 was a notable monument of law reform, replacing an incoherent series of statutes and equitable rules by a coherent statutory scheme. And then he sets out some of the history which Lord Walker has already done so. So if one turns the page to 181, paragraph 181 on manuscript page 4545, the reason for enacting section 26 C of the Limitation Act 1939, now section 32(1)(c) of the Act of 1980, was that courts of equity had previously applied the equitable rule relating to fraud by analogy to cases of mistake. And then he, in turn, goes through the various cases, Brooks, Bank and Smith, Denison, Shuckburgh, which Lord Walker did, and para 183, Phillips, Higgins and Harper. And over the page 4548, he deals with the issue of mistake more generally. And if one turns to 4551, paragraph 193, page 4551, in their printed case, paragraph 67, the test claimants rely on this statement of principle, and in particular the passage which I've just italicised, as authority for the proposition that EU law requires a right to choose from the range of national remedies. Of course, the test claimants do have a right to choose either or both of a Woolwich equitable claim or a claim based on mistake. Neither of the Acts of 2004 and 2007 took it away from them. Their real complaint is not that the right to claim on the basis of mistake of law has been withdrawn, but that the law has been changed to make it subject to a period of limitation running from the date of payment in the same way as the limitation period for a Woolwich equitable claim. The argument, as it was developed at the hearing, was that even on the footing that a Woolwich equitable cause of action was enough, and that the United Kingdom is not obliged to confer an additional right to recover tax paid by mistake subject to an extended limitation period, since it has chosen to do so, the principle of effectiveness requires that that right with its extended limitation period should remain available for the purpose of recovering tax charged contrary to EU law. This submission is accepted by the majority of the present appeal. I regret that I am unable to accept it for three reasons. He's not questioning for one moment that there is an extended period. He's already been through that. He's just saying that he doesn't think there's anything wrong with EU law truncating it, under EU law with Section 320 truncating it. And then one comes to my Lord Reid at page 4559. Paragraph 209. Lord Walker and Lord Sumption have expressed different views about the way in which EU law applies to the grounds of action available to the test claimants for the recovery of taxes which were levied contrary to EU law, and in particular about the way in which EU law applies to legislation which shortened retroactively and without transitional provisions the limitation period applicable to one of those grounds of action. In my opinion, Lord Walker's analysis of the compatibility of Section 320 of the Finance Act 2004 and Section 107 of the Finance Act 2007 with the principle of effectiveness and of the compatibility of the latter provision with the principle of protection of legitimate expectations is consistent with the relevant case law of the Court of Justice of the European Union. I agree with his reasoning and conclusions in relation to those issues, as well as in relation to the issues of domestic law before the Court. And then paragraph 210. The difficulties in this case arise partly from the fact that the relevant principles of English law have been in the course of development during much of the relevant period of time. Principal milestones along the road are three decisions of the House of Lords. First, in 1992, the House of Lords held that a taxpayer was entitled to recover taxes paid in response to an unlawful demand. That's the Woolwich equitable case. Secondly, in 1998, the House of Lords held that money paid under a mistake of law was recoverable, Kleinwort-Benson. Thirdly, in 2006, the House of Lords held that the latter principle applied to taxes paid under a mistake of law, including taxes paid in ignorance of the fact that the legislation under which they were levied was incompatible with EU law. That's DMG. Two other important matters were also decided in that case. The first concerned the limitation period applicable to the claim. In terms of Section 32(1)(c) of the Limitation Act, that period would not begin to run until the mistake was discovered or could with reasonable diligence have been discovered. The House of Lords held that in the circumstances of the case, the mistake could not be discovered until the incompatibility of the tax with EU law had been established by a judgment of the Court of Justice. The second matter was that the fact that the taxpayer might have a concurrent ground of action under the Woolwich principle, which was subject to a limitation period running from the date of payment, didn't prevent it from pursuing its claim on the ground of mistake if the extended limitation period best suited its interests. Finally, in its present decision, this Court has held that a taxpayer who pays taxes in compliance with legislation which is incompatible with EU law has a ground of action under the Woolwich principle in addition to any ground of action which may be available on the basis of mistake. So there it's quite plain my Lord has fully focused on all the issues that arose and is agreeing with the majority view. And that majority view was a universal view on the domestic law issues. And then if one turns to 4569, or 4570. No, I think 4569, paragraph 236. In the present case, the claims are for the repayment of taxes unduly levied between 1973 and 1999, when the relevant limitation period was 6 years. That period generally ran from the date of payment, but in an action for relief from the consequences of a mistake, the period was extended. It did not begin to run until the claimant discovered the mistake or could with reasonable diligence have discovered it, section 32(1)(c, reenacting a provision previously contained in section 12 of the Limitation Act.
That's a misprint, presumably. That presumably is a misprint. It shouldn't be section 12, should it? That's section 20, I think.
Exactly.
Or 12, or 26, rather.
26. It should be 26, indeed. As Lord Walker has explained at paragraphs 103 to 104, it has been established in this case that the payments were made under a mistake about the lawfulness of the tax regimes under which they were paid, and it was only after the Court of Justice issued its judgment in the Mattel-Gesellschaft and Höchst case that it was generally appreciated that the UK corporation tax regime was open to challenge as infringing community law. A well-advised company in the position of the claimants would then have had grounds for considering that it was entitled to the repayment of tax which had been levied contrary to community law, and there was at least a reasonable prospect that it could rely upon the extended limitation period provided by section 32(1)(c of the 1980 Act in order to recover any taxes paid more than 6 years before the proceedings were begun. In order to do so, it would of course have had to base its claim upon the mistake ground of action. The BAT action was begun in June 2003, the Aegis action on 8 September 2003. In each action, the claim was based upon the mistake ground of action, as well as the unlawful demand ground of action, and reliance was placed on section 32(1)(c. Section 320 of the 2004 Act, enacted in July 2004, excluded the application of section 32(1)(c of the 1980 Act in relation to taxation matters where the action was brought on or after 8 September 2003. Section 107 of the 2007 Act, enacted in July 2007, excluded the application of 32(1)(c where the action was brought prior to 8 September 2003, where it was brought prior to 8 September 2003. It is apparent from that summary that the claims, so far as they relate to payments made more than 6 years before the proceedings were commenced, have always been dependent on the application of section 32(1)(c of the 1980 Act. The effect of the legislation of 2004 and 2007 is thus to deprive the claimants retrospectively of the ability to pursue their claims so far as they relate to those payments. Since the legislation was retroactive in its effect, there was nothing the claimants could do to avoid its operation. That, of course, was the point of making the legislation retroactive. Since the legislation, paragraph 238, since the legislation retroactively restricts the possibility of repayment to claimants who brought an action within 6 years of the date of the payment, rather than 6 years of the date when their mistake was discovered or could with reasonable diligence have been discovered, it deprives persons who do not satisfy that condition of any possibility of exercising the right to repayment derived from EU law which they previously enjoyed. In the circumstances of this case, it retroactively renders the taxes unduly paid by the BAT Group prior to June 1997 and by the Aegis Group prior to September 1997 irrecoverable, taxes whose reimbursement had been timelessly sought under the law then in place. It therefore renders impossible in practice the exercise of rights derived from the EU treaties which national courts are bound to protect. This is the first reason why I have reached the provisional conclusion that it's contrary to EU law and cannot be relied on in these proceedings. My Lords, the matters were thrashed out. There was no doubt in any of their Lordships' minds that 32(1)(c, with its extended limitation period, did apply to the mistakes of law which were comprised which were present when the payments of the ACT and the D5 tax were wrongly made. I will leave it to my learned friend to go through the details of the statements of claim, the various admissions, and so on and so forth.
I come back to the point I made before. I mean, you certainly made the case that this was all gone into as thoroughly as one could expect, except that the point we're now faced with wasn't taken by anyone. Now, is this a res judicata point you're making? Is this a estoppel point? An abuse of process? How do you analyse it in legal terms?
Well, I've read the Virgin case. You can say it's an abuse for the matter to be raised now. It is res judicata. It's all three of them or some of them. It doesn't really matter what.
Well, no,
Well, I know you put it to my learned friend.
Because you've got to decide it. And I don't see how it can be res judicata. The point has never been argued, as I understand principles of res judicata. But,
Well, it depends how you look at it, because if a decision, if an argument is based upon a premise, and the decision turns upon the argument based upon that premise, then that premise is a matter which would need to have been disputed at the time, because otherwise it is binding. You cannot just say, oh, well, this point wasn't thought of, and therefore it can be...
there must be authority on that.
Well, my learned friend would take...
All I'm saying, I can't, with great respect to your learned junior, being taken through the pleadings, I suspect, is not going to help us very much, is it? Unless there's some...
Yes. But my learned friend, who is not my junior, he's just my colleague, I wouldn't say he's... But anyway, there we are. He will deal with this. We have a little demarcation of work on this. I mean, when I first saw this, I thought, is this a joke? You cannot be going through this again and making me sit through this again, surely. No, I agree that this particular point didn't come up, but of course it didn't come up because it was absolutely obvious that it was implicit in everything that was said. Everything that was said by every judge and by every counsel.
Yes, you can make that point again, and I can certainly see there are other people who might wonder why they have to sit through it all again. But one's still got to find the legal basis of it and say we're precluded from considering the point. If we are, we can all go home and get on to other things.
Can I leave that to my learned friend? I mean, I did at the permission hearing raise the Virgin case and said that we would want to argue that this cannot be argued because it is the foundation of all the discussion that took place at the first hearing. So, my lord, I'm sorry, I'm not going to. I haven't read the particular authority. He's just pointed me
very
out.
adequately.
Yes, but there is authority, and if there isn't, your lordships can create it. If I may say so. I mean, you seem to be very adept at creating other new developments in the law. So, so how you would actually phrase this is something I'd wait to read, if I may put it that way. Anyway, can I move on?
I mean, it's obviously a point of enormous importance.
Oh, yes.
Not only in this case, but generally. But it's just that my feeling is that reading great chunks of the pleadings doesn't make any stronger the point you've made. This was actually gone into in all these judgments.
Yeah, but I wouldn't read even a morsel of the pleadings, but there have been so many admissions made, there have been so many statements made.
Yes, we know that. We've been told that.
Yes, I'll be shown that. Well, may I move on then to my submission that section 32(1)(c) and the proposition that it extends to both mistakes of law and mistakes of fact has underpinned the development of both case law and statute law for more than a decade. We have seen section 320 of the Finance Act 2004. My learned friend tries to shake that off by saying, oh, well, it's not unknown in tax matters for for the avoidance of doubt provisions to be introduced. And then just in case they're wrong as a matter of, in case their understanding of the law isn't upheld by the courts. And Lord, that is a bit of a parody of Section 320 in the way it was introduced and the way it was argued. It was never suggested that for the avoidance of doubt, Section 32(1)(c) should be read as not including mistakes of law in respect of payment of taxation under the control of whatever it is, the Commissioners of Inland Revenue. But even if that were to be the case, how on earth can that be said in relation to Part 8C of the Corporation Tax Act 2010, which was introduced, I forget when, 2015? It's in the core volume 1. Best place to pick this up is actually in our skeletons. I'm not sure it's set out anywhere else. If we look at core 1 at tab 9, this is the 45% tax on restitutionary interest. And at page 3976, set out in our skeleton what Mr. David Gawke, the Financial Secretary to the Treasury, said to Parliament when introducing these provisions. If we just read para 62 of our skeleton, or whatever it's called, written case. Section 38, Finance Number 2 Act 2015, introduced a 45% corporation tax rate chargeable on restitution interest. The provisions were inserted into the Corporation Taxes Act 2010 as Part 8C. It is actually an authorities one. I don't recommend that you read it. They are almost impenetrable, with the sections having the extraordinary numbering of sections 35(7)YA to 35(7)YW. In basic terms, this 45% tax applies to interest awarded in relation to claims for repayment of tax paid under mistake of law relating to taxation. The 45% tax applies to the totality of the restitution interest and cannot be reduced by any reliefs or set-offs. In introducing these draconian provisions to Parliament, the Financial Secretary to the Treasury, Mr. David Gawke, stated that new Clause 8 addresses an unfairness whereby in certain claims for repayment of tax and restitution for interest payments, taxpayers might receive a significant additional benefit at the expense of the public purse. The interest payments targeted by this clause arise from claims made under common law which stretch over a large number of years, in some cases going back to 1973, and represent a unique set of circumstances. New Clause 8 will ensure that a principled and targeted system is in place to address a potential unfairness whereby a few businesses receive significant benefits resulting from the unique nature of this litigation at the expense of the public purse. There's no question that insofar as Parliament listened to Mr. Gawke and read the provisions at all, there's no question that the reason this was passed was because it was seen to redress what appeared to be an extraordinary position that claims could be made going back to 1973. And what claims? Claims going back under the common law. Basically, these claims. So they're statutory provisions driven by the acceptance of the proposition that Section 32(1)(c) does provide an extended limitation period for payments made under a mistake of law. But then we have the case law. We have the Littlewoods case, where in this House, in this court, the fact that that claims could be made under common law for mistake of law, payments made under mistake of law, payments of tax, could go back years and years and years, was one of the justifications for saying that it's inappropriate for compound interest to be awarded. That's in Authorities 2 at tab 17. And if one picks it up at paragraph 5, it's page 606. This is the judgment of the whole court, delivered by Lords Reid and Lord Hodge, Lord Carnworth, Newberger and Lord Clark agreeing. Para 5, in these proceedings commenced in 2007, Littlewood seek additional interest calculated on a compound basis on the ground that such interest is due under the common law. The additional interest totals 1.25 billion. The amount involved is so enormous because under the law of limitation applicable to common law claims, the ordinary limitation period of 6 years does not begin to run where an action is for relief for the consequences of a mistake until the claimant has discovered the mistake or could with reasonable diligence have discovered it. Littlewoods maintain, that's section 32(1)(c), Littlewoods maintain that the period over which the interest is to be compounded on that basis is over 40 years. My Lord, although that case turned on the provisions of the Value Added Tax Act, there's no doubt that the extent of the potential claims under 32(1)(c) was a matter which influenced the decision of the court in reaching its conclusion that English law did not require, that European law did not require compound interest to be paid, and that the relevant provisions, I think it was section 80, if I remember rightly, the Value Added Tax Act, should be read in a particular way so as not to permit that result. And then we have the prudential decision, again of this court, again in Authorities 2, this time at tab 22. And at manuscript page, this court was Lord Reid, Lord Sumption, Lord Carnworth, Lord Hodge and Lord Mance. One turns to 735. We see that what is handed down as the judgment of the court. Just above it, you'll notice that Burrows QC replied. So Professor Burrows was involved in that as well. If one turns to manuscript page 748,
I'm afraid MS is actually rather more banal than manuscript. It actually stands for memory stick.
Is it?
Yeah.
I'm afraid so.
Oh, God.
I don't think I've ever seen it in manuscript.
Oh, memory stick. Gosh. Is that what your Lordship was having problems with yesterday?
No, we don't actually use memory sticks much, but that's sort of survived.
It's memory stick, is it? Oh,
Yeah.
good Lord.
Well, we do
Perhaps,
still-
perhaps EB, electronic bundle, is a more accurate
Yeah.
description of
Yes.
what
Yes,
the
we-
beach is.
We still do get the memory sticks, but most of us don't use them.
He wasn't listening to any of my submissions because I said many times.
It's the accent. I've never penetrated it in over 13 years or 15 years of this litigation, but never mind. That's why I read the transcript so avidly to find what you've said. Now, paragraph...
Which MS number are we?
We're at memory stick 748, paragraph 40. Insofar as the revenue wished to advance submissions questioning the soundness of the reasoning in the Semprametals case, the court is not inclined to prevent them from doing so in the particular circumstances of this case. So this court was being very benevolent to the revenue, allowing them to raise an argument they hadn't actually asked to raise. And then one turns to 753. And you'll see the legal developments since Sempre Metals. And then paragraph 55. A number of relevant developments in the law have occurred since the Sempre Metals case in 2008. First, the jurisprudence of the ECJ has developed since its Metallgesellschaft judgment. And then they refer to Littlewoods. And if one goes over page to 754, para 61, thirdly, in the Kleinwort-Benson case, it was realised that allowing recovery of payments made under a mistake of law could create problems as the law of limitation then stood, since Section 32(1)(c) of the 1980 Act would enable claims to be brought within 6 years of the mistake being discovered, no matter how long in the past the payment had been made. So that was a realisation in Kleinwort-Benson. For that reason, Lord Brown-Wilkinson, that's 364, considered that the correct course would be for the House to indicate that an alteration in the law is desirable, but leave it to the Law Commission and Parliament to produce a satisfactory statutory change in the law, which at one and the same time both introduces the new cause of action and also properly regulates the limitation period. The majority, however, were unpersuaded that reform of the law of restitution should be delayed and assumed that legislation could be enacted if Parliament considered it desirable to address the limitation question. See, for example, Lord Hoffman at 401. Parliament duly enacted such legislation. By the time of the decision in the Sempre Metals case, the majority therefore considered that the seriously untoward consequences for the revenue, as Lord Nichols described as in para 125, of claims arising from mistaken payments of tax in the distant past, were guarded against by Section 320 of the Finance Act 2004, which provided that Section 32(1)(c) of the 1980 Act should not apply in relation to the mistake of law relating to a taxation matter under the care and management of the Commissioners of Inland Revenue. And one turns
But
over
why are you telling us all this? We know all this. The question is, there we decided these various developments meant that we had to look at that point.
Yeah, but
I mean, the point that we regarded this Section 32(1)(c) as having been settled by TMG is not surprising. We did.
well, of course, yes.
So
but
why do you need to tell us that?
I'm telling you that because look what you did with it.
Yeah, your point is that important decisions have been made by this court
Absolutely.
on the assumption
Precisely.
that DMG is correct.
Precisely.
That is your point.
Precisely.
Yes.
Well, I'm glad. I mean, but I didn't know you'd got it until you said you got it. But I wonder, this is really critical. It's a sort of a bootstrap argument. 32(1)(c), oh my word, it causes havoc. So what do? In Littlewoods we do this. And then in Prudential we do that, we cut down Sempre. And now the revenue turned around and said, but actually 32(1)(c) doesn't have that effect at all. Are they going to undertake to invite the court to reopen the issue which was closed in Prudential, and so on and so forth? Anyway, that's a sort of a rhetorical flourish which perhaps I could have avoided.
Yes.
There we are.
I mean, the trouble is I keep on interrupting. I don't mean to, because it's frustrating, because I think this is a really difficult issue you're raising, as to how, clearly here we regarded ourselves as needing to sort of review the law because of the sort of these developments. And it may be said again, so, well, how much more do we need to review this point? But I mean, that's a slightly unsettled way of dealing with the law. And what I'm looking for is the sort of formulation of some principle which sets the limits of what is appropriate for us to do within the scope of the practice direction, actually, is really what it's
Well, but the answer is the jurisprudence that's developed since the practice direction. You look to see to what extent the decision which you are seeking to revisit has, and then there are various negatives. Is it out of tune with social developments, etc.? But one of the things you have to take account is, has it been embedded in either other important case law decisions of the highest court of the land, or legislation, or both? These are developments which need to be taken into account. It's judgmental. There's no checklist. It's not a sort of multiple choice question. that you have, it's an evaluation. It's a matter of judgment. At some stage, probably be tomorrow morning, I'll actually be inviting you to conclude that Lord Gough was right. So there's no need to depart from it, and that the House of Lords was right in DMG as well.
Yes, but
they
if
were
we get
actually
to that
right.
point, well, that makes it all much easier.
Yeah, of course it does.
The problem
yes.
is if we're persuaded that Lord Gough was clearly wrong, and then you're saying, well, we should stuck with that position for a time because of these various developments.
Yes, I would say it would be surprising if all your lordships were to hold that Lord Gough, in an area of his particular expertise, was clearly wrong. You might have an intellectual preference that leans in a different direction, but it would be surprising. But I've been surprised previously in my legal career. But it could be judicial preference. Judicial preference, there was a nice expression used by an Australian judge or whatever it is not the touchstone.
Right, sorry,
No. So may I move on to how it all could have been avoided? I'm not sure what the legal relevance is, to be perfectly honest, but hopefully this will come out in discussion. But to me it does seem relevant, perhaps in the evaluation of whether you should depart from a previous decision. Is this all down to the Commissioners of Inland Revenue getting it wrong over and over again? That's a sort of a paraphrase. Let's begin with the Limitation Act 1980. It was a Consolidation Act, but as with all Consolidation Acts, one does take into account the legal position at the time of consolidation. In 1980, at that time, there was widespread disquiet and criticism across the common law world at the proposition that mistakes of law could not found actions. That the distinction between mistakes of fact and mistakes of law were so, chimerical, I forget what it is. Elusive, so elusive, that there should not be two different codes of law applicable. And the next stage is Lipkin-Gorman in 1991, when the House of Lords developed for the first time the freestanding principle of restitution for unjust enrichment. Wasn't there before, it was there. So let's just pause a moment. Did section 32(1)(c), the extended time period for mistake, apply to Lipkin-Gorman type actions? They weren't there in 1980, they weren't there in 1939.
That wasn't actually in the state case, was it? It was.
No, it wasn't. But it was a free. It was a. And I'm saying it's a freestanding principle. It wasn't there. But if there were a mistake underlying that claim, that wasn't there in 1980. Surely it would not be suggested that section 32(1)(c) would somehow be inapplicable to a Lipkin-Gorman type claim where there was where a mistake was the basis. Small point. Then you have Klein-Wark-Benson itself, October 1998. That's followed by the Law Commission. It coincided with the Law Commission consideration of the whole question of limitation. It's followed in July 2001 by the Law Commission's report, chaired by my Lord. Very detailed. I'll be coming to it and taking your lordships through it. Very detailed accepting that as a matter of principle, there is no principled reason for distinguishing between claims for mistake of law and mistake of fact. There was a consultation document that was very long, and parties were invited, interested parties were invited to comment. Amongst the commentators were the Commissioners of Inland Revenue and the Commissioners of Customs and Excise. The Hurst case, judgment was given in 2001. Who was a party to the Hurst case? Well, technically the United Kingdom, but in fact, Her Majesty's Revenue and Customs, or the Inland Revenue, as I think they can't remember what their incarnation was at that time. They were the parties. They knew all about it. If a well-advised company, somehow understanding, somehow learning what was in the particulars of claim of Hurst and Metalgesellschaft in 1995, should have realized at that time that they had a mistake-based claim. Surely the Inland Revenue should have realized it at that time. They were parties to it. They were parties to the Hurst case. They knew the disruption that the Hurst case would cause if the Court of Justice decided in favour of the claimants in that case. And then there's one other case which has not been directly referred to, but only it would have been referred to extensively at the first hearing here, the Marks and Spencer tea cakes case. I think it was the tea cakes case, where the extended limitation period was summarily truncated under the VAT Act, and the Court of Justice held that these summary truncations of limitation periods are contrary to European law. Who was a party to that case? The Revenue, Customs and Excise. They were the other party. That was in 2002. The DMG case, Mr. Justice Park's decision in 2003, I forget which month. But that was the decision. When was the case raised? Several years before. Who was a party to the case? The Inland Revenue. It can't have come as a surprise to them that Section 32(1)(c) was being used by claimants. They may not have liked the decision of Mr. Justice Park, but they could hardly be surprised that it was being used. They were the parties. They were at the other end of the particulars of claim. And what do? Well, September, actually it was July, if I remember rightly, in September 2003, they introduced Section 320 without a transitional period. Having been told by the Court of Justice in the Marks and Spencer's case, you need a transitional period. For heaven's sake, how many blunders can be made by the Revenue? They've had every opportunity for year after year after year. They could have introduced Section 320 ages before, as soon as they were alerted to the possibility that people were relying on Section 32(1)(c). Instead, they introduced it without a transitional period, and it goes fut. And they come along here, 16 years later, and saying, oh, by the way, because it went fut, can you please reverse Time Benson? So that's the history. As I say, I'm not entirely sure what the legal significance is. But if you're evaluating whether it is appropriate to depart from the decision of the majority of the court in Kleinwort-Benson and DMG and this court itself, it is something to take into account. Now, I said that it is entirely principled to equate mistakes of law and mistakes of fact in the context of limitation. It is not the case that mistakes of law give rise to problems of, oh my word, when are you going to, with reasonable diligence, be able to discover them, whereas mistakes of fact don't suffer from those problems. I think it was Lord Hope who said that there may well be problems with mistakes of fact as well as mistakes of law, and I'll illustrate it with my own sort of an example I've done to amuse myself, which I'll come to in a moment. But to say that having a mistake of law, extending the limitation period until the time when that mistake could with due diligence be discovered is unprincipled, is an absurd proposition, given that this is exactly the conclusion reached by the Law Commission in 2001 after very exhaustive discussion and presumably consideration of this precise issue. The Law Commission recommended no difference between mistake of fact and mistake of law, and they said so explicitly, both in the discussion and in the draft bill. What's the Law Commission for? It's to think about points of principle and in what way the law can be improved. It's an improvement, they were suggesting. Now, the way they dealt with the fact that the indeterminate, to use the word of Lord Gough, that there might be an indeterminate period, the way they dealt with that was to say there should be a general 3-year period from discovery of whatever it is, with a 10-year long stop. That you can't go more than 10 years. A very sensible, if I may say so with respect, a very sensible recommendation, with a let-out for personal injury cases, where as a matter of discretion it could be extended further. It's a fat package of very sensibly thought through, principled proposals. So it's quite wrong to say that it's unprincipled to have an extended limitation period for mistakes of law. It's principled. So again, when one comes to the practice statement, what is more in keeping with social considerations or social developments? The thinking of the Law Commission on this is something which needs to be taken into account. Without wishing to embarrass my Lord Carnworth, I would like to take your Lordships to the Law Commission report because they set out their reasoning very clearly. It's to be found in the Respondents' additional documents at tab.
Sorry, Mr. Aronson, can you identify the bundle for us? We've got rather
It's called Respondents' Additional Documents. It has 5 tabs.
Oh, yeah.
It's also got some wonderful electronic pagination. You've got it
Yes,
too.
additional memory stick page. That's excellent. Now, in my old-fashioned way, actually just fingering it, apart from its 11 Roman-numbered numeraled pages, it's 302 pages long. This is a major, major piece of work by the Law Commission. If we turn to the additional memory stick, page 29, actually it's probably better to look at page 20 just to see the contents. There's part 1, which is an introduction, which is the scope of the review, the problems with the current law. Part 2, an outline of the current law. Part 3, Reform 1, the core regime. Part 4, application of the core regime. Part 5, additional issues. And then Part 6, summary of recommendations. Appendix A, draft limitation bill with explanatory notes. And Appendix B, list of persons and organisations who commented on the consultation paper. So if we turn to page 29, we find...
Can I just remind myself, the consultation paper was 1998. I think may have been just before my time. But that would have been Professor Burrows, I think, wouldn't it? Leading then. My recollection is that then Professor Beale came in and took over the project. I mean, it doesn't matter, but it's quite a high level.
No, it's a shame Professor Burrows isn't here on that side in order to be able to show you directly. He was there till 1999. So, yes, so. This may explain why Professor Burrows isn't on that side at this particular moment. But anyway.
Coming up here. So.
No, it didn't stop Lord Sumption from having a go until the very last moment. My Lord, there would have been nothing preparatory at all for him to continue this case here. The fact that his views conflict with those of HMRC may perhaps have more to do with it, but never mind, we shall... That's just the advocate's point. We're on 1.9 on memory stick page 29. More importantly, this is under the sort of the overview, the Limitation Act 1980 can't be applied straightforwardly to causes of action such as the newly recognised law of restitution founded on unjust enrichment. This has been recently illustrated by the Kleinwort-Benson Lincoln City Council. The House of Lords recognised that money paid under a mistake of law should be recoverable and held that Section 32(1) of the Limitation Act 1980 applied so that the period of limitation doesn't begin to run until the claimant could with reasonable diligence have discovered the mistake. Where the mistake results from a change in the common law after the relevant payment has been made, the limitation period under the current law will only begin to run when the claimant should have discovered the change, no matter how long before the change the payment has been made. This led Lord Gough to remark, I realise that this consequence may not have been fully appreciated at the time when this provision was enacted, and further that the recognition of the right of common law to recover money on the ground that it was paid under mistake of law may call for legislative reform to provide for some time limit to the right of recovery in such cases. So this was something right at the start, page 3, grappled with by the committee. Well, then it turns to page 48. Under paragraph 5, claims for restitution. Paragraph 248, unjust enrichment was only recognised by the House of Lords as an independent cause of action in 1991. Hence, the Limitation Act 1980 doesn't contain a limitation period which explicitly applies to restitutionary claims. So that's just repeating the point I was making less eloquently a few minutes ago. It wasn't there in 1980, but is anyone suggesting for one moment restitutionary claims aren't covered by 32(1)(c)? The 1980 Act...
Well, there were always restitutionary claims. They were simply rationalised in a different way. They were treated as resting... Sort of what we're talking about were treated as resting on an implied contract. Well, so they were regarded as falling within Section 5.
Well, yes, but innocent receipt, I think, was a defence under the old law, and that had gone with the new approach, which is unjust enrichment.
I mean, this is very much of its time in regarding Lipkin Gorman as heralding some sort of revolution.
Well, it was a change. As I say, innocent receipt is not a defence to a Lipkin Gorman claim. The question is the enrichment unjust? You might say there's a subtle difference, but it's a subtle difference of importance. Innocent receipt would be a defence pre-1991, and that would knock out an awful lot of claims.
But I mean, the dissonance between the terms of the 1939 Limitation Act and the availability of claims for money you hadn't received was precisely what was noted in Rediplock, where they say the language isn't apt to cover these claims, but we're going to treat them as being covered by what was then Section 2. Because of the point that I raised before, because of the importance of finding a place within the Limitation Act for them, because of the policy of the Act to provide for certainty and limitation in advancing certainty.
My Lord, but I would accept that, but what the Law Commission is doing here is saying, okay, we've now got a new formulation, if you like, of the law of restitution. How do we make that work?
Key may be in footnote 101.
Yes.
A previous chair of the Law Commission had told us to get on with it.
Yes. There we are. Yes, there is. There are many interesting footnotes in this. Anyway, so as I was saying, 249, the 1980 Act does, however, contain provisions applicable to many restitutionary claims. For example, Section 9 sets a 6-year limitation period for claims under the Law Reform Frustrated Contracts Act. Section 10.1 sets a 2-year limitation period for claims under the Civil Liability Contribution Act 1978, etc., etc. If one turns to page 58, we have an explicit discussion of relief from the consequences of a mistake. Para 2.89. Where an action is for relief from the consequences of a mistake, the limitation period doesn't begin to run until the claimant discovers the mistake or could with reasonable diligence discover it. In Kleinwort, Benson and Lincoln City Council, a majority of the House of Lords held that there's a general right to recover money paid under a mistake, thus abrogating the rule that money paid under a mistake of law is irrecoverable. The House of Lords also held that an action to recover the money falls within the terms of 32(1)(c) of the 1980 Act, so that the relevant limitation period is 6 years from the date on which the mistake is discoverable. Accordingly, if a payment is made pursuant to the law as stated by a decision of the Court of Appeal, and the House of Lords later overrules that decision, the payment may be recovered up to 6 years after the House of Lords case. This aspect of the decision prompted Lord Brown-Wilkinson and Lord Lloyd to dissent, Lord Brown-Wilkinson expressing his disagreement in the following terms. I don't think I need to read that again. So this has all been very fully considered by the Law Commission. Over the page, there's footnote 174, which just says, it appears their Lordship's attention wasn't drawn to our provisional recommendation that there should be a uniform long-stop limitation period of 10 years from the date of the relevant act or omission applicable to all actions other than actions in respect of personal injuries. So anyway, there we are. If one then turns to page 66, they set out proposals for the core regime, as they call it. Para 3.1. In this part, we consider the main components of the recommended core regime, namely, when should time start to run in relation to a claim, how long should the primary limitation period be, the long-stop limitation period, the factors extending or excluding the limitation periods, should the court have a discretion to disapply a limitation period, and agreements to change the limitation period. And 3.2, it may prove helpful first to explain what we mean by claim. We're concerned with the case where the claimant is bringing legal proceedings to seek a form of relief from the defendant. Relief for these purposes may fall into one of the following 3 categories: a remedy for a wrong, restitution, or the enforcement of a right. Claims for a remedy for a wrong will include any claims for damages for a breach of duty by the defendant, such as a claim for damages for negligence or for breach of contract. Restitutionary claims will include any claim for unjust enrichment, such as for the recovery of money paid under mistake. Then I think we can turn over to 3.7. Their recommendation is, we recommend that the primary limitation period should start to run from the date of knowledge rather than, for example, the date of the cause of action accrues. So that was a very radical new approach proposed by the Law Commission. Date of knowledge should be the basic rule for the start of the limitation period. Then if one goes to page 74, definition of the date of knowledge, fact and law. Now we come to the nub as far as this case is concerned, at page 74, 3.35, in the consultation paper we discussed without reaching a provisional view the part which knowledge of the law should play in the definition of the date of knowledge. Two alternatives were suggested to consultees. One, that knowledge for the purpose of the date of knowledge should always include knowledge of the law, including knowledge of one's entitlement to a legal remedy for what has occurred. Two, that knowledge should include knowledge of the law only insofar as such knowledge is necessary for the claimant to know all the elements of his or her cause of action. For example, where the claim is for restitution of payments made by a mistake of law, one has to know the true legal position to know that one has made a mistake. Those consultees who responded on this point were divided on the issue. Approximately 30% agreed with the first alternative proposed, suggesting that this was necessary to do justice to the claimant, and then the others took a different view. Over the page, we come to the recommendation at 339. This is on memory stick page 75. We recommend that for the purposes of the test from the date of knowledge, the claimant is presumed to know the law, so that the claimant's lack of knowledge that the facts would or would not as a matter of law give rise to a cause of action shall be irrelevant. This will not apply to, then there's one, and then we come to brackets 2. This will not apply to a cause of action in respect of restitution based on a mistake of law, and the fact that a mistake of law has been or may have been made shall be treated as one of the facts giving rise to the cause of action. So the view was that one should take the fact that there's an allegation of a mistake of law, that should be treated as one of the facts that would need to be taken into account in determining when there was knowledge actual or constructive, equating mistake of fact to mistake of law. Then he goes on to ask what was actual knowledge, but if we turn to page 147, obviously I'm missing out an awful lot here.
I mean, 338 is quite important because that's really the explanation of section 2. I mean, it's very,
Yes.
very much based on Claimants and the last
Yes.
paragraphs. I mean, I don't think it adds to your point. I just thought one shouldn't miss those.
There was reasoning. Yes, because I'm cutting things out doesn't mean that I think they are irrelevant. It just means that I have a limited time for addressing your lordships.
No, it's just I'm reminding myself.
Yeah, no, this is very thoroughly gone into. So my note takes me to page 147. Hopefully that is the right page. And it's 4. Yes. Claims for restitution. This is the recommendation.
Sorry, page?
147.
Thank you.
Paragraph 4.76. We provisionally proposed in the consultation paper that restitutionary claims should be subject to the core regime. This was accepted by all consultees who responded to this question. Since the publication of the consultation paper, Kleinwort-Benson has been decided by the House of Lords. This decision has recognised that money paid under a mistake of law should be recoverable, even where the mistake in question results from a change in the law after the relevant payment has been made. The Law Lords held that Section 32(1) of the Limitation Act 1980 applied, so that the period of limitation didn't begin to run until the claimant could, with reasonable diligence, have discovered the mistake. Where the courts change an understanding of the law which is applied for several years and under which the claimant made the relevant payment, the claimant will have 6 years from that date to bring his or her claim, however long the relevant payments were made. The following comments were made. And then he quotes Lord Gough's and Lord Hoffman's concern, the obvious problem. 478. The problems referred to will be considerably alleviated by the implementation of the core limitation regime which we propose. The primary limitation period of 3 years will run from the date on which the claimant discovers or ought reasonably to discover the facts which give rise to the cause of action, including the fact that his view of the law was mistaken, the identity of the defendant and the fact the defendant has received a significant benefit. This provides a similar starting point to that set out under 32(1)(c) of the Limitation Act, namely the date of the decision change in the law. However, the long-stop limitation period of 10 years will run from the date of the accrual of the cause of action. In a claim to recover money paid under mistake of law, this will be the date on which the defendant is enriched. No enrichment received by the defendant over 10 years before the date of judgment could therefore be recovered. So that was the principled and pragmatic approach which the Law Commission was recommending. I think there was a comment in DMG, I seem to remember reading it, that there was an assumption that this recommendation was going to be was going to be enacted. It just wasn't. So all the work is there for the record, but for little else, which is a great shame. If we go to the draft bill at page 257, you'll see how this is expressed, and it's expressed very clearly and neatly. 257 draft bill. Section 1. It is a defence to a civil claim that the claim was not made before the end of the period of 3 years from the date of knowledge of the claimant. 2. It is also a defence to a civil claim that the claim was not made before the end of a period of 10 years from the starting date in relation to the cause of action on which the claim is founded. 3. Subsections 1 and 2 are subject to the following provisions of this Act. 4. In this Act, civil claim means a claim made in civil proceedings in which the claimant seeks A, a remedy for a wrong, B, restitution, and C, the enforcement of a right. And then if one goes to draft section 2 over the next page, 258, subject to the following provisions under the heading Date of Knowledge, subject to the following provisions of this section and this Act, any reference in this Act to a person's date of knowledge is a reference to the date on which he first had knowledge of the facts which give rise to the cause of action, the identity of the defendant, and C, where injury, loss, or damage has occurred or a benefit has been obtained, the fact that the injury, loss, damage, or benefit is significant. 2. Subject to subsections 3 and 4, in determining the date on which a person first had knowledge of the facts which give rise to a cause of action, there shall be disregarded the extent, if any, of his knowledge on any date of whether those facts would or would not, as a matter of law, give rise to a cause of action. That's subject to subsections 3 and 4. 3. In the case of a cause of action in respect of a breach of duty, whether in tort, in contract, or otherwise, which involves a failure to give correct advice as to the law, subsection 1 shall have effect as if it also required knowledge to be had of the fact that correct advice had not been or may not have been given. And then 4, the key provision for our case, in the case of a cause of action in respect of restitution based on a mistake of law, subsection 1 shall have effect as if it also required knowledge to be had of the fact that a mistake of law had been or may have been made. Now, I emphasise may have been made because that is beginning to imply a sensible and restriction to the operation of the provision. And I will come to that and say, well, that is exactly what we have in the context of Section 32 in relation to cases of fraud and concealment. And I'll develop that argument a little bit later. But if one takes the context of Section 32, we end up with something not dissimilar to what the Law Commission was recommending. But my conclusion, over the page I should just mention, 259, constructive knowledge, section 4, for the purposes of this Act, a person's knowledge includes knowledge which he might reasonably have been expected to acquire from facts observable or ascertainable by him, or where he has acted unreasonably and not seeking appropriate expert advice, from facts ascertainable by him with the help of such advice. So, a very careful...
I mean, if you're leaving that, I see from the Law Commission website that they report that the then government in 2002 accepted the recommendations in principle, but in November 2009 the government announced that it would not be taking the reforms forward. So it had a lease of life between 2002 and 2009.
An expectation of a lease of life, one might say. Yes.
It seems to me that it was accepted for a period, but it was then not pursued.
Yes,
It doesn't say why not.
yes. But the basic point I'm making, the essential point I'm making here, is that the reasoning of the Law Commission demonstrates that it is perfectly principled to treat mistakes of law as having an extended limitation period in the same way as mistakes of fact, no more, no less. May I now come to my fanciful example, just to demonstrate how there's no real difference, as I think Lord Hope said, between mistakes of fact and mistakes.
That's before you leave the Law Commission.
Yes.
Ourselves, but it'd be interesting to see, has anyone checked the consultation paper? I suppose it's pre-Claimants, so probably not very helpful.
Yes. I couldn't find it last night, I'm afraid, amongst the mountain of stuff. We could provide a note. It wouldn't be overnight, but maybe after the case, if Lordships find it helpful to see what
Might just be interesting to see what Professor Burrows was saying about it at that stage.
When you discover a mistake is an elusive concept. Let me give this example. Let's say that in 1990, I agree with my learned friend Mr. Hewitt to buy the Michelangelo that's on his wall for £10 million. Now, we have a detailed provenance certificate from the Uffizi Gallery that shows where it's been, right from when it was first painted in whatever it was, 1560 or whatever, up to the date when it entered Pump Court tax chambers, or in fact Pump Court before it even moved to Bedford Row. And then in 1995, let's assume that some historian of the buildings of Italy just wrote an article noting with sadness how a particular church had burnt down in Florence, and that church was one of the churches which had housed this painting, according to the certificate of provenance, but noting that many of the paintings had been saved. So that's 1995. Move on 5 years. Some art historian, for want of amusement, writes an article in whatever is the leading journal of art historians, dealing with the colours which various painters hated, and commented that Michelangelo seemed to have a particular aversion to pink. And I look at my wall and I find that one of the cherubs is holding a medallion that is pink. But I hadn't read that article, nor had I read the article dealing with the building that burnt down. And then in 2005, so in 5 yearly steps, there is a new pigment dating technology that has become publicly available that can date with remarkable accuracy the age of a painting. But I'm still admiring this painting on the wall, but unfortunately I have a problem with damp and call in the builders, and the builder's ladder knocks out in 2015. It knocks out a large chunk of my Michelangelo. And underneath can be seen quite clearly part of a portrait of William Pitt the Younger. I did, my lord. I've got to keep myself awake in this case. So while my learned friend was going on this morning, I was thinking about this as an elusive. At what point, with reasonable diligence, should I have discovered the mistake? Now, plainly, when I actually see William Pitt the Younger being someone well versed in tax and knowing that he was around in whatever it was, 1803 or whatever, 1842. That's after Michelangelo. I'm not sure exactly when he died, but something like 1570 or something. So this was unlikely to be a genuine Michelangelo, Victorian copy. So that's in 2015. 2005, am I meant, with reasonable diligence, to have read about the apparent aversion of Michelangelo to pink? Or 5 years earlier, to have read about the sad fate of that church in Florence? At what point, with reasonable diligence, could I discover the mistake in thinking it was a genuine Michelangelo? I don't know what the answer is. But what's the difference between that and the sort of issues that arise in mistakes of law? I mean, if this case went on for a few more days and Mr. Rabinovich were going on dealing with the issues he did and had to repeat it, I'd probably think of 6 or 7 or 8 other examples. There's no principal difference between discovery with reasonable diligence of the date of discovery of a mistake of law or a mistake of fact. Some mistakes of fact are obvious, some mistakes of law are obvious, others are much more subtle. Hence, the 10-year long stop is a very sensible, principled proposal. Now, can I move on to contexts? Because my learned friend has invited you to select as the test, not sure which in his order of priority test, but take as a test the date when you were able to formulate a statement of claim. I think that's one of his horses running in this race. And he takes that, he says, from other contexts in the Limitation Act. So far, no dispute. It's a very good test in that context. But that context is very specific. And that test arose in that context precisely because of the, if I can pronounce it, specificity, probably can't, the specific nature of one of the statutory conditions, which is that the damage or injury was attributable, in inverted commas, attributable to the action of the defendant or for which the defendant is responsible. Case law, long established, endorsed over and over and over again, accepted, or, no, wrong word, determined that in that context, that's the personal injuries context, which also then was the same principles were applied for latent defects. But in that context, attributable meant no more than might be attributable, could possibly be attributable. A reasonable possibility that it was attributable, not that it was, a reasonable possibility. Given that, and that is an essential nature, and you'll see this is in every single sentence my learned friend referred to with emphasis, if he emphasized any sentences, the ones he should have emphasized for his case. In every sentence, the word is attributable. Given that meaning, that attributable means might be attributed, it's perfectly reasonable to say that you could, with reasonable diligence, have knowledge of the fact that it might be attributed as soon as you're alerted to the fact that you've got a problem and it's somehow linked. The example I think I put in the skeleton argument because it was so easy to understand is a case called Dobby, of which I think 1 page is only in the bundle, because it's the end of another case. It may not even be there in the electronic bundle. Case of Dobby, lady goes in and has an operation on her knee. Shortly afterwards, she finds that she has something called foot drop, which presumably means that the muscles holding up the nerve, keeping the foot, is not operating properly. Now, she might have thought immediately after the surgical procedure that this is one of the after effects and it will wear off, as one very often these things do in orthopedic matters. But it didn't wear off. It just carried on. The question that arose in that particular case, I'm not taking you to it, but it's just an example. I'll take you to the AAB case itself. The question that arose, at what point should she, with reasonable diligence, have discovered that it could possibly be caused by the operation on her knee? And the answer was, surely, by the time she actually goes along to lawyers and they start thinking about statements of claim. That's all. They're not saying it was caused by the operation. It could have been caused by physiotherapy after the operation. It could have been caused by when she banged her leg on the bed getting out to go to the to have a shower or whatever. It could have been caused by that, but it might quite easily have been caused by that. At that point, you could, with reasonable diligence, have concluded, have discovered that it might have been caused by the surgeon. That is the context of the AB against Ministry of Defence case. And I'm going to, before taking you to it in detail, I'm going to make another point. That case, Court of 7 of this court, split 4-3. The minority, Lady Hale, I forget who the other, Lord Phillips, if I remember rightly, Lady Hale and one other. That minority said belief is not the same as knowledge. The majority held, majority of 4, held that belief was sufficient. But in that majority, Lord Walker made the point explicitly that he comes to that conclusion, or his conclusion, he's comforted in that conclusion, by the meaning of attributability, which had been developed over the years in the courts. Had it not been for that, it's a reasonable inference to draw that he would have been on the other side. It's a very difficult issue, very, very difficult issue, a very hard case. I don't know what my own conclusion would be if I had to judge it. It's a very difficult case. Here are these sailors, soldiers, engineers exposed to alpha and beta radiation from nuclear tests, not knowing whether the various ailments which were developing years afterwards were caused by those tests, and not being able to find that out because the science hasn't developed enough, even now, or even then in 2016, to determine the issue. Hence the minority saying, well, until the science has developed enough so you can determine it, it's not right that the Limitation Act should cut them off. The majority taking the different view, saying enough is enough. You can't carry on having the Ministry of Defence at risk of liability scores of years after the event. A very difficult case, turning on the meaning of attributability. Now, having made that submission, I have to make it good, but I shall do that by inviting you to turn to Authorities 1 at tab 7. You'll see at memory stick page 40 the composition of the court: Lord Phillips, Lord Walker, Lord Brown, Lord Mance, Lord Carr. Lord Carr was the other dissenter, and Lord Wilson. If you turn just a few pages to page 48, you'll see that against letter B, Charles Gibson, well, I said 2016, it's 2013, Charles Gibson and Deanne Mulkey and David Evans and Adam Heppenstall, instructed by Treasury Solicitor for the defendant. If you drop down to letter F, you'll see their submission. The issue in each of the present cases is when on the particular facts the claimant had knowledge within the meaning of section 14(1)(b) of the 1980 Act that the injury in question was capable of being attributed to this exposure to radiation. Not was, but was capable. That was their submission. And that is what is picked up over and over again in the judgments. If one goes to page 52, Lord Wilson. Paragraph 2. I should read the first paragraph. I consider that each of the 9 appeals should be dismissed. In my respectful view, the approach of Lord Phillips, Baroness Hale, and Lord Carr to the meaning of the word knowledge in sections 11(4) and 14(1) of the Limitation Act is misconceived and would throw the practical application of the subsections into disarray. There's a very sharp conflict between the minority and majority in this case. I also consider that any exercise of the discretion under section 33 so as to permit any of the 9 actions to proceed would be aberrant in circumstances in which they have no real prospect of success. You can see why the minority felt so strongly. There's no prospect of success because they can't prove their claim because the science isn't there yet to let them know whether alpha and beta radiation can cause the same problems as gamma radiation. We all know gamma radiation causes these problems, but there was no knowledge whether alpha and beta radiation caused it. Knowledge was being developed as that case was proceeding. 2, what is the nature of the exercise which the court conducts when asked by a defendant to rule that an action in respect of personal injuries is time-barred under section 11 of the Act? Subsection 4 provides that the action shall not be brought after the expiration of 3 years from A, the date on which the cause of action accrued, or B, the date of knowledge, if later, of the person injured. The subsection refers at A to the cause of action, notwithstanding that if the action is to continue, it may well transpire that the claimant has no cause of action. When the subsection turns at B to the date of knowledge of later and so requires the court to appraise the claimant's knowledge of the 4 facts specified in section 14(1), which relate to, although do not comprise all the elements of, his cause of action, the assumption that indeed he has a cause of action remains. That explains why sections 11(4)(b) and 14(1) refer to knowledge, which can only be matters which are true, rather than belief, which can be in matters which are untrue, as well as those in those which are true. Knowledge of the second of the 4 facts specified in section 14(1) is that the injury was attributable in whole or part to the act or omission which is alleged to constitute negligence, nuisance, or breach of duty. This knowledge of attributability, as it is convenient to describe it, is predicated upon the assumption that the claimant has a valid cause of action and thus would be able to establish, among other things, even in the teeth of opposition from the defendant, not just attributability, and now I emphasize, which means only that there is a real possibility that the act or omission caused the injury. Spargo and North Essex District Health Authority, 1997, per Lord Justice Brooke. So that's the first indication. Attributability means only that there's a real possibility. Now, this is picked up over and over again. We turn to page 53. Actually, it's easier to pick it up from paragraph 3, otherwise it's incoherent, on page 52, the foot of 52. The assumption that in an inquiry under sections 11(4) and 14(1) of the Act, the cause of action exists leads me with inevitable discomfiture to a profound disagreement with one of the essential foundations for the conclusions of the minority in this court. It was the preferred view of Mr. Justice Foskett, upon which he would have acted had he not felt constrained by authority to act otherwise, that the veterans who issued their claim on 23rd December 2004 acquired the requisite knowledge of attributability only on a later date, namely 29 June 2007, when the Rowland report was privately presented to them. The Rowland report was a report dealing with the effects of radiation. It was privately. It is the conclusion of the minority that A, it is indeed possible for a claimant to lack knowledge of attributability at the time when he issues his claim, and if so, time will not have begun to run against him. And B, irrespective of whether the later presentation to them of the Rowland report then led them to acquire it, the veterans lacked such knowledge when they issued their claim, with the result that none of them is time-barred. In my view, however, it is a legal impossibility for a claimant to lack knowledge of attributability for the purposes of Section 14.1 at a time after the date of issue of the claim. By that date, he must in law have had knowledge of it. Pursuant to CPR 22.1a.4, he must verify his claim form by a statement that he believes that the facts stated in it are true. The word in the statement of truth is believes rather than knows, only because, of course, the assumption that the cause of action exists doesn't apply to the claim form. That it exists is indeed only a claim. Although the statement of truth covers wider ground, it can, in my view, be regarded as an explicit recognition by the claimant that he has knowledge of attributability for the purposes of 14.1. And then if one goes to Lord Walker at 62, you see the same point made, having regard to the specific meaning of attributability in this context. Paragraph 28 on page 62. The decision of the House of Lords in Cartledge and Jopling revealed a serious injustice in the law relating to limitation of actions. Workmen suffering from an insidious industrial disease, pneumoconiosis, might find that their rights of action against their employers were statute barred before they even knew that they were suffering from the disease. To remedy that injustice, Parliament enacted the Limitation Act 1963. That act was severely criticised by the House of Lords and Smith and Central Asbestos, and it was repealed and replaced by the Limitation Act 1975, now consolidated as part of the Limitation Act 1980. The need for the claimant to know the legal significance of the proposed defendant's acts or omissions, one of the main points of criticism, was removed. But two important general features were reproduced, though in a different form, in the new legislation. One was that the commencement of the limitation period was to be triggered by the claimant's actual or constructive knowledge of certain facts. The other was that these included the fact that the claimant's personal injuries were, inverted commas, attributable, close inverted commas, to conduct of the proposed defendant, which was described in the original statute in terms of negligence, nuisance, or breach of duty, but in the new statute as the act or omission which is alleged to constitute negligence, nuisance, or breach of duty. The new legislation also produced difficult problems for the courts. They can be roughly grouped under two general heads. First, what is it that the claimant has to know at the date of knowledge? The what question. Secondly, how must the claimant know what he has to know? That is, what state of mind, assessed subjectively or objectively or by a mixture of the two, amounts to knowledge for this purpose. The how question. The what question depends on the interpretation and application of Section 14.1 of the 1980 Act, and in particular, since it gives rise to most of the problems, Section 14.1b, which relates to the fact that the injury was attributable in whole or in part to the act or omission which is alleged to constitute negligence, nuisance, or breach of duty. And if one turns to 64, the what question, above para 33, the case law on the concept of, inverted commas, attributable, close inverted commas, has developed in a coherent way. It is not without its difficulties, especially in cases involving specialised and technical areas of expertise discussed by Lord Mance and Howard and Fawcett's. But on the whole, the case law is consistent and provides a workable test. In Smith and Central Asbestos, Lord Pearson quoted the Oxford English Dictionary definition of attributable as capable of being attributed or ascribed, especially as owing to, produced by, and stated that attributable refers to causation. This view has been, that was 1973, that case, this view has been consistently followed in later authorities on the legislation in its present form. In Howard and Fawcett's, in 2006, Lord Scott of Fuscott quoted a passage from the judgment of Lord Justice Hoffman in Hallam, Eames and Merit Syndicates, which conveniently sets out some of the most important cases. And then one drops to para 35 on the same page, 64. In this context, therefore, attributable has been interpreted by the courts as directed to a real possibility of a causal link. Lord Nichols in Howard and Fawcett, citing National Eli Lilly, in that case, Lord Justice Purchase, who gave the judgment of the court, quoted with approval at page 797 some observations by Mr. Justice Hidden in his second judgment on the preliminary issue. And this is the quote, Mr. Justice Hidden. The stark strength of the word knowledge does not stand alone. It is knowledge that attribution is merely possible, a real possibility, not a fanciful one, a possible cause as opposed to a probable cause of the injury. At this point, the what question and the how question come into close proximity. And this is, as I say, this is, I might say, the swing consideration that made him go with the majority. At this point, the what question and the how question come into close proximity, since confident knowledge that there may be some causal link between two events is not dissimilar from a less confident belief that there is indeed a causal link between them. So the way in which attributable has been interpreted in the case law eases the court's task in deciding whether knowledge includes more or less firmly held belief. But it doesn't remove all the difficulties, as this appeal shows. So my learned friend in his Skeleton and Yesterday develops his argument based on these provisions, which are quite different from Section 32. They set out the rules in great detail, what you have to have knowledge of. And all you have to have knowledge of is some possible link. And asks this court now to determine that the same test should apply to knowledge of a mistake. Just saying, well, it means that there may have been a mistake. Of course, your lordships could do that. But it doesn't follow in any way from these cases, which are very specific to the language used in section 14. If one moves now to page 68, we'll see one other point that Lord Walker makes. To alleviate the problem, there is section 33 of the Limitation Act. It's not in your bundles, but I have it, had it separately printed, we'll give to you. Section 33 gives discretion to the court to extend the limitation period. It's discretion in the case of personal injuries. It's specific to personal injuries. I'm not sure whether it includes latent defects as well. I'll have to have a look. And so what you have is a trio. You have knowledge, what's meant by that. You have attributability, what's meant by that. And then you have the discretionary extension. And because attributability has been given such a weak meaning, might be attributable, you can paraphrase it as. So you can have knowledge at a much earlier stage, and that shouldn't lead to injustice because section 33 can always extend the period. That's the reasoning in this judgment. So if one goes to page 68, para 47, Lord Walker says, taken together, the unanimous decisions of the House of Lords and A. Hoare and Adams and Bracknell appear to me to mark a decisive shift away from a subjective approach on these issues. What was within a claimant's actual knowledge is undoubtedly a subjective question, but the notion that whether a claimant has knowledge depends both on the information he has received and upon what he makes of it can no longer be accepted, at any rate without a lot of qualification. The recent authorities recognise that the policy of the law is for the date of knowledge to be ascertained in the same way for all claimants without regard to their personal characteristics, which can be taken into account at a later stage of exercising discretion under section 33. So that's how he sees it. Section 33 allows the court to have regard to the particular circumstances of the individual, to alleviate what would otherwise is likely to have the start date for limitation at an earlier date than might otherwise be fair. As Lord Hoffman put it in Adams and Bracknell, the Court of Appeal in Forbes was right in saying that the introduction of the discretion under Section 33 has altered the balance. And then there's a discussion with actual knowledge and constructive knowledge that begins at 48, but if we go to page 70, paragraph 53, in line with that, in Halford and Brooks, Lord Donaldson put forward the test of knowledge as know with sufficient confidence to justify embarking on the preliminaries to issue a writ, such as submitting a claim to the proposed defendant, taking legal or other advice, and collecting evidence. This formulation has been taken up in later cases, notably Nashnila Lilly, Spargo, Howard and Fawcett. That's a formidable line of authority, but still there's no clear consensus. Most strikingly, in Sneezek and Bundy, Lord Justice Judge rejected the notion that time automatically starts to run against a client who has taken legal advice, whereas Simon Brown, Lord Justice Simon Brown, found it difficult indeed to imagine a case where, having consulted a solicitor with a view to making a claim for compensation, a claimant could still be held lacking in the requisite knowledge. I respectfully but unhesitatingly prefer the view of Lord Justice Judge. So one can see that Lord Walker is very much concerned that one shouldn't have too early a start for these personal injury limitation periods. And then one turns to 71, paragraph 57. To return to the original formulation in Halford and Brooks, it's clear that Lord Donaldson envisaged that the collection of evidence to support the claimant's claim was something which would normally come after the date of knowledge, when the claimant first knows he has a possible claim. That's how it was understood by Lord Justice Hoffman in Brodie and Clapham. And if one goes to page 73, just the last sentence, just to, but I read paragraph 66. My learned friend has read it, and I'd read it with my own emphases. I do, however, have reservations about Lord Wilson's proposition, concurred in by Lord Mance, that the effect of the statutory provisions is that the claimant is assumed to have a cause of action. No doubt this is correct in the general sense that every claimant who issues a claim form commencing contentious proceedings is assumed to have a cause of action unless and until his particulars of claim is struck out or the action is discontinued or dismissed. But I do not see that this general assumption helps, and it may actually be a distraction in understanding the way that sections 11, 14 and 14A of the 1980 Act operate. The putative character of the section 14.1b and section 14A 8A facts depends not on any implicit assumption, but on the long-standing and consistent meaning which the courts have given to attributable. So I'm inclined to think this is a novel and unnecessary requirement. There's no doubt whatever that Lord Walker has identified the key point in these personal injury-related provisions in the Limitation Act as being the particular meaning given to attributability, which only appears in those sections. Lord Brown, at page 74, paragraph 69, makes the same point. I too would dismiss these appeals for the reasons given by Lord Walker, Lord Mance and Lord Wilson. I do not believe that there are any significant differences between their three judgments, but if there are, and if something approaching a canonical text is required, I would align myself principally with Lord Wilson's reasoning. Perhaps the most critical proposition to which each of the above three judgments commits is, in Lord Wilson's words at paragraph 3, it is a legal impossibility for a claimant to lack knowledge of attributability for the purpose of section 14.1 at a time after the date of issue of his claim. And then at the foot of para 71, on the same page, in short, once a claimant issues his claim, it's no longer open open to him to say that he still lacks the knowledge necessary by reference to sections 11 and 14 to set the time running. Then one can turn over to Lord Mance, again in the majority, at para 78 on memory stick page 75. Lord Phillips and Lord Wilson have expressed radically different views about the concept of knowledge in the Limitation Act 1980. The present appeals concern personal injury claims, and their disagreement relates to the knowledge, in inverted commas, referred to in sections 11.4b, 12.2b, and 14. But parallel disagreement must necessarily exist between them with regard to sections 11a, 4b, 5b, inserted by section 6.6 and paragraph 1 to schedule 1 to the Consumer Protection Act, actions in respect of defective products, and 14a, inserted by sections 1 and 4.1.2 of the Latent Damage Act 1986, special time limit for negligence actions other than personal injuries where facts relevant to cause of action are not known at date of accrual. The correct resolution of this disagreement is of general importance. All those provisions have the same basic text including attributability. We'll look at that perhaps in the morning. In my opinion, Lord Wilson's analysis is consistent with and correct in the light of prior authority, and is the analysis which makes sense of the statute and its purpose. And I agree with his reasoning and conclusions. I shall not repeat his examination of authority, but content myself with a few points. First, the statute assumes that a cause of action has accrued, section 11.4a, and that facts exist of which knowledge may exist, section 14.1. Such facts include an injury which is significant, section 14.1a, and which is attributable to an act or omission now alleged to constitute negligence, nuisance, or breach of duty, 14.1b. Attributable here means capable of being attributed as a possible cause of the damage as opposed to a probable. Because I don't wish to labour the point anymore. My learned friend is inviting your lordship to apply what he says is this test set out in another context in the Limitation Act. But the key point is that other context has very specific drafting, quite different from section 32. I'm all in favour, I always have been in favour, of construing legislation in its context. Very important. There is nothing in the context of the personal injuries limitation rules that is applicable to the mistake of fact or law, section 32, or to fraud, or to concealment, because the language is quite different, and the jurisprudence that is grown up around section 14 in relation to personal injuries is specific to, referable to, and makes sense by reference to personal injuries limitation, especially in the context where section 33, which is 27 sections away, but nonetheless is part of the same. Section 33 applies just to those cases where there's a discretion to extend what would otherwise be a limitation period that begins early. Now, my lord, I want to move at this point. I see it's 5:02, so maybe I just indicate what I'm going to say tomorrow in relation to the context that matters. And the context that matters is section 32. Section 32 deals with fraud, concealment, and mistake. We've seen how concealment has changed. I think it used to say fraudulent concealment. I think it was something now, but it has the same meaning. The language has changed. Sefton is a very interesting case. There are very few cases on any of these things, as it happens, very few indeed on mistake. So all the problems which we've been discussing here, in practice, they don't seem to have risen very much. But in Sefton's case, what the court decided, well, you remember the facts of the case. There was a defaulting solicitor and an accountant whose job it was to certify that the accounts of the solicitor, Cray, I think the solicitor was called, or something like that, the accountant should have done the job properly. Didn't. Various clients of the solicitors found they'd lost a great deal of money. Complaints were raised with the Law Society, whose compensation fund was at risk. Primary issue in relation to limitation was, when did the cause of action accrue? Was it when the Law Society was at risk of a claim, which was the view taken by Lord Briggs and Lord Justice Newberger in minority, or was it when the first actual claim was made, which was the view of the majority in the Court of Appeal? And as that was within 6 years of the claim, there was no problem. So that was the main dispute. But then there was the question of, was there an extended limitation period because of the fraud? And the test that was proposed and adopted in that particular case was a very straightforward one. Well, you're deemed to have discovered the fraud, when you were properly able to plead the fraud. Properly able. Not able, but properly able. What is the test for the proper ability to plead? Well, that's been laid down at Metcalfe and Mandel, another House of Lords case. It's when there is sufficient material available to give a prima facie indication that there's been fraud, a prima facie case of fraud, sufficient material. I'll come to that case. It's not in the bundles, but I've had it printed out. Metcalfe and Mandel, 2003, one appeal cases. Perhaps I should hand it up this evening before your lordships adjourn, so you can just...
Yes, that would be helpful.
But the test there is when... This is laid down by bar rules. You cannot plead fraud unless you have sufficient material that evinces a prima facie case. The issue in that case, Metcalfe and Mandel, is there wasn't any admissible material, but there was non-admissible material, and that was the key, the crunch. The original bar rules required you to have admissible material. That was changed. And the case actually was for a wasted costs order, saying counsel pleaded fraud when there wasn't that evidence available. Held, wasted cost order should be discharged because there was available material, even if it wasn't admissible material. And I will say very few cases on Section 32, but that test is a principled test. When there is material available which provides indicates a prima facie case that a mistake has been made, that's when you might say that is a perfectly principled point for saying the limitation period starts to run. In the present context, what is that material? Well, the material has to be the decision of the ECJ in FII 1, because until then, there was no prima facie case. But that just happens to turn on the facts. But if your lordships are looking for a principle, rather than say the final court of appeal, what is the final court of appeal? Your lordships have demonstrated, in the way you've dealt with Sempra, that there isn't a final court of appeal. You might change your mind again and change, final court of appeal may be appropriate in any given circumstance, but that isn't the principal test. The principal test needs to be a point of principle. And what is wrong with the principle that's been adopted in Sefton, which was a House of Lords case, what is wrong with the, actually it was the Court of Appeal, that point never, well, it wasn't disputed in the House of Lords. What's wrong with that as a test? Is there material which suggests prima facie that BAT made a mistake in paying the tax? Yes, there is. What was that material? Well, you can argue what the material was. We say it's pretty obvious. I'll develop that tomorrow. It was FII in the ECJ. It wasn't Hurst. Hurst didn't deal with credits, explicitly didn't deal with credits. In fact, the Advocate General says, I'm not dealing with the issue of credits, which was one of the sub-points that was raised because it's so complicated. I'm just dealing with the group income point, group income point. So I leave you with that thought. May I hand up the...
So we have the advantage that both of you are adopting Sefton as being an indication of the correct approach.
Well, I am at the moment. I am. I don't know whether my known friend's going to stick to it or whether he's going to try to dodge it tomorrow. But at the moment,
Just looking
as
for
at
some
4 o'clock.
common ground.
Yes, it's common ground. Yes.
Yeah, well, that's quite useful. Here's my case. Thank you. Thank you.
Also, we have section 33 printed out. It's not in the bundle. The bundle stops halfway through section 33.
Well, you can perhaps let our usher have it after we've adjourned.
Yes.
But I think that's enough for today. We'll see you again at 10:30 tomorrow.